My grandmother died with £34,000 less than she should have had, and my aunt had the receipts. I mean that literally. My aunt had organised the paperwork. She had been granted power of attorney, the legal authority to manage another person's financial affairs when they are unable to do so themselves, during my grandmother's hospitalisation in the spring. The hospitalisation had lasted 11 weeks, the result of a stroke that had left my grandmother partially incapacitated, but according to her medical records, mentally present and capable of decision-making with appropriate support. My aunt had visited daily. The rest of us had not, a fact my aunt had communicated to us at regular intervals using the particular tone of a woman who is banking goodwill for future use. This is the part where I need to confess something. I liked my aunt. Past tense, clearly, but I genuinely liked her. She was funny in the dry way of someone who has seen everything and is mildly entertained by the continuing spectacle of human behaviour. She organised things, she remembered birthdays. She was, by the family consensus, the reliable one. She was also, as it turned out, the one who had moved £34,000 out of my grandmother's savings account in 17 separate transfers across 3 months, while my grandmother lay in a hospital bed 60 miles away. I discovered this at a bank branch in Coventry on a Tuesday morning in October, 6 weeks after the funeral. I had gone in to inquire about the estate accounts as one of the named beneficiaries under the will. My grandmother had left her estate equally to her 4 grandchildren, with a small bequest to a cat rescue charity she had supported for 20 years, which I find darkly appropriate in retrospect. The bank clerk, who had the particular expression of someone delivering information she would rather not deliver, told me that the savings account had a balance of £247. I said, "I think there's been a mistake." She showed me the statement. 17 transfers, March through June, all to the same account. Amounts ranging from £800 to £4,500, all processed under the power of attorney. I sat in the bank chair for quite a long time. The neighbour's name was Pat, retired teacher, sharp as a pin, and the kind of person who notices things and writes them down, which turned out to be more useful than anyone had expected. Pat had lived next door to my grandmother for 22 years. During the hospitalisation, my aunt had been using my grandmother's house as a base, a fact we had all accepted without much thought, since someone needed to be keeping an eye on the property. Pat had seen my aunt come and go. Pat had also been present on 4 occasions when my aunt had received phone calls in the garden that Pat had overheard without intending to, and which Pat had noted in the small diary she kept for what she described as general record-keeping purposes. Pat had not known at the time that those notes would matter. She had simply found the calls unusual. She had found the tone of them unusual. She had heard on at least 2 occasions her aunt discussing money in amounts that seemed large, and a plan that Pat had not understood but had noted anyway, with dates. My solicitor was a woman called Rachel, contentious probate specialist, practiced in the particular skill of not being surprised by families. Rachel told me in our first meeting that what I was describing was a potential case of financial abuse under a power of attorney, which is an increasingly common and chronically under-investigated area of civil law. She said the key question was capacity, whether my grandmother had understood and consented to the transfers at the time they were made, and that the medical records from the hospitalisation would be critical. We obtained the medical records. My grandmother's consultants had documented her cognitive status at regular intervals throughout the 11 weeks. In the first 3 weeks, during which 4 of the 17 transfers had been made, she had been assessed as having significantly impaired capacity due to the acute phase of the stroke. The clinical notes from those weeks described her as confused, disoriented, and unable to reliably consent to medical procedures, let alone financial transactions. 4 transfers made while she was too confused to consent to a blood test. The midpoint arrived when my aunt, through her solicitor, offered to repay £12,000 and have the matter dropped. 12. Out of 34,000, as if a third of the money constituted a reasonable settlement for what amounted on the evidence to financial abuse of an elderly woman during a period of acute medical vulnerability. Rachel recommended declining. I declined. My aunt's legal team indicated they would contest any further claim vigorously. The case proceeded to a civil hearing in the county court. The key evidence arrived 3 days before the hearing in the form of Pat's diary. Rachel had requested disclosure of any relevant documentation from Pat, expecting nothing of legal significance. Pat produced a small blue notebook, the kind you get in a pound shop, spiral bound, with a pen tucked into the spiral, containing 3 months of dated entries. The relevant entries were on 4 pages. They recorded the substance of the phone calls Pat had overheard, including amounts discussed, references to accounts, and one entry from a Tuesday in April that read, "She asked about the other account. He said it was straightforward. An unidentified male. A voice on the phone. Someone who had advised my aunt on what she was doing." The solicitor on the other side went very quiet when Pat's diary was disclosed. The shocking twist was not the diary, though the diary was significant enough. The twist was what the diary prompted my aunt's solicitor to do, which was to contact Rachel the following morning and request an urgent meeting. In that meeting, my aunt's solicitor disclosed, voluntarily without being asked, that the account the money had been transferred to was not my aunt's personal account. It was a joint account. Joint between my aunt and my uncle, who had died 4 years earlier, and whose estate, under the terms of his will, had passed entirely to my aunt. The account, therefore, was legally my aunt's. But the undisclosed fact was that a third of the money transferred into that account had been moved again, within days of each transfer, to a second account, an account belonging to my aunt's son, my cousin. My cousin had a gambling problem that the family had known about in vague terms for years and had never directly discussed. My aunt had been taking my grandmother's money and giving it to her son to cover his debts. She had done it 17 times over 3 months. She had done it while my grandmother lay in a hospital bed, being assessed for capacity to consent to a blood test. The unexpected acquittal, the resolution I did not expect, was that my cousin repaid his share voluntarily, in full, the day after the disclosure. He transferred it back without being ordered to. His solicitor told Rachel that he had not known until that morning the full source of the money his mother had been giving him. I cannot verify that. I do not know whether to believe it. I have thought about it a great deal. The total recovery was 31,000 of the 34. 3,000 remained unaccounted for, spent on things that left no retrievable trail. Rachel said this was within the normal range of outcome for a case of this type. I did not find that as comforting as I think she intended. My grandmother left behind a will that said her estate should be divided equally between 4 grandchildren. The estate that was eventually distributed was approximately £31,000 lighter than it should have been. Each of us received £7,750 less than she intended us to have. My aunt has not spoken to any of us since October. My cousin sent me a message in November that said he was sorry. I did not reply. What do you do with a sorry that arrives after the money has been spent? I am genuinely asking. I have not worked out the answer yet.